Okay, good morning everyone and welcome to this morning's licensing panel hearing. We'll begin by a round of introductions. My name's Councillor Amanda Pinnock. I'm the chair of the panel. Move over to my colleagues. Councillor Ryler.
Just introduce myself. I'm Councillor Ryler and I'm Councillor for Home Valley South in Holmfirth.
Thank you. Councillor Davis.
Hi, I'm Councillor Paola Davis, Councillor for Almonbury Ward on the panel today.
Thank you. The legal officer.
Tahir Hanif, Senior Legal Advisor.
Okay, the licensing officer.
Morning, Chair. Anne Warbutt, Licensing Officer from the Licensing Department.
And Stephanie Mashter, Senior Licensing Officer.
And the applicant, Mr. Ashton, and representative.
You go first.
I'm Jonathan, Sunday name Jonathan Ashton, commonly known as Jay, the applicant.
Hi, my name's Nick Semper. I'll be representing the applicant today. The applicant's wife Laura is also with us, and also the manager of the Mirror Bar that's at Mapplewell is here in case you have any... Sorry? Ashley. Sorry about that, Ashley. In case you have any particular questions for her.
The gentleman behind you. Okay, over to my left, the objectors.
Patrick Froggatt, resident of 3 Sunnybank.
Andrew Kellett, resident at 19 Sunnybank.
George Lodge, another resident of Sunnybank.
Was there meant to be another person? Is it Miss Harrison?
That's my wife. She couldn't make it today, I'm afraid. She's got work commitments.
And then environmental health.
Hi, Alexandra Gary from Environmental Health.
Thank you. So we'll quickly go through the agenda before we deal with the main matter as to why we're here today. So site visits were undertaken by myself and my colleagues. Membership of the panel, we've already dealt with that. Who's here today? Who's attending? Minutes of the previous meeting. I think it was just myself and Councillor Ryler that was at that meeting. Happy to approve those, Councillor Ryler? Thank you. Those are approved. Okay. Any declarations? Councillor Ryler? Councillor Davis?
No, none from me, thank you.
Any deputations or petitions?
None received.
Public question time?
None received.
Thank you. Okay, so item 8 is in relation to an application for the grant of a new premises licence in respect of Maplewell Bottle Shop Limited, situated at 337 to 339 Wakefield Road, Denbydale, Huddersfield. Before we begin, I just want to confirm that this is webcast today, so it can be watched and observed by anyone taking an interest in what's going on today. And also, in relation to everybody here, there's a question that I need to ask before we move on. So, have you received the licensing hearing procedure, which explains how the hearing will be conducted, and that you've read it and understood it? So that's over to the applicants. Have you received that, read it and understood it? Fantastic. Likewise with the objectors, read it, understood it? Thank you. Okay. All right then. So I'll ask the licensing officer then to outline the application that's made today. Thank you.
Thank you, Chair. The purpose of the report is to inform members of an application for the grant of a premises licence. 5 representations have been received and is therefore referred to this panel for determination. So, information required to make a decision. The application was received on the 29th of April 24 and it is for the address that's already been said, 337 to 339 Wakefield Road, Denbydale, Huddersfield. A copy of the application and plan are attached to Appendix A to this report. The details of the licensable activities applied for are as follows: the retail sale of alcohol on and off the premises, Monday to Sunday, 24 hours. Live music, indoors and outdoors, Sunday to Thursday, 1500 to 2000 hours, and recorded music in and outdoors, Sunday to Thursday, 10 a.m. to 2300 hours, Friday to Saturday, 10 a.m. to midnight. I have informed all parties of a late update to the application. Can I confirm that everybody's received that? That essentially updates the application as follows. The operating schedule has been updated. So for your reference, the operating schedule is page M on the application form, which goes through how the licensing objectives will be met. There is a copy of the red line plan, which I don't think it was as clear on the first application. That was emailed out on Friday. I do have printed copies if anybody needs a copy. And most importantly, regulated entertainment has been withdrawn from the application. So, as said, in total 5 representations have been received, one of which is from Environmental Health, and the remaining representations are from residents. The representations consider that the following licensing objectives would not be met should the licence be granted, those being the prevention of crime and disorder, public safety, and the prevention of public nuisance. In your bundle, you will have Appendix B, which has all of the representations attached. For the purpose of this application, this is a grant for a new licence to former news agents. Now, planning permission at this stage has not been applied for. However, just make it clear for the panel and all members here, I'm sure panel members are aware of this, that we do not need to consider planning here. There's a separate process, and there's no reason, should you be minded to grant the application on the basis of planning being absent, why that would interfere with a decision to grant the licence. Excuse me. Just for your benefit, the premises have not been licensed previously. There's no historical licenses attached to this application. A location plan is also attached to the bundle at Appendix C. Members, I believe, have conducted an independent site visit, and with regard to relevant information for reference purposes, Appendix D includes relevant sections of the 182 guidance from the Home Secretary with relation to the licensing objectives. And I have included Appendix E, although it may not necessarily be relevant this morning, with the update to the application. Appendix E is with regard to the deregulation of live and recorded music, particularly section 16 within that bundle. If there's any questions on that later on, I'd be happy to deal with those. As far as the consultation has been concerned, with the exception of Environmental Health, none of the other responsible authorities have made representation. As said, 5 representations have been received, 1 from Environmental Health and the rest from members of the public. The panel are to determine the application. When determining the application, members would have regard to representations, may take the following steps for the promotion of the licensing objectives. Can grant the application with appropriate conditions, exclude from the scope of the licence any licensable activities which relate to this application, or reject the application. Members are invited to determine the application. Thank you very much, Chair.
Thank you. We'll move over to questions. So I just want a little bit of clarity for everybody in the room. So we've received a revised proposal put forward by the
Chair.
applicant's representatives in respect of withdrawing the regulated activity.
Correct.
So I just want to be clear about what the panel are being asked to consider today.
Okay.
So originally the application was for the retail sale of alcohol on and off premises 12 a.m. to 11:59 p.m.
Yes.
And that would be it. That's all the panel are asking, being asked to
it,
consider.
yes.
So the live music and the recorded music, that's going.
That's going, yes.
Thank
As far as licensable activities are concerned, between the hours of 8 and 2300 hours, live and recorded music, for the benefit of, or should I say, for the purpose of this application, they're not regarded as licensable. The licensing requirements do not apply.
Thank you.
Thank you, Chair.
I'll move over to my colleagues to see if there's any questions. Councillor Ryler?
Yeah, would you be able to clarify the usage of the garden space, the outdoor space, how you would see it working?
Maybe, sorry Chair, maybe that's a question for the applicant.
No.
As far as we're concerned, the other licensable activities, they're contained within the red line border of the plan, so the sales and retail sale of alcohol can take place there. Thank you.
Thank you. Councillor Davis, any questions for the officer?
So, yeah, sorry, just to clarify for me, please. I understand that the application, the playing of live and recorded music has been withdrawn from the application, but as it's an unlicensed activity, it could still carry on.
Correct. Within
regard for a license.
Within the hours of 8 to 2300 hours.
For less than 500.
They are not regarded as
perfect, thank you.
Licensable activities any longer, perfect. As amendments to the Licensing Act enacted in 2015, I believe.
Yep, thank you.
Thank you.
Thank you. Any questions from the applicant to the officer?
No, it's very fair summary of where we're up to. Thank you.
Objectors, any questions from the licensing officer at this stage?
The amended photo with the boundaries is not correct. Where it comes down to the border of one of the properties, Mr. Buxton left a metre of land where he planted his bushes for maintenance of the outbuilding that is on the property of 337339. According to where the red boundary is, that comes right up to the bush and encompasses the bush on Mr. Buxton's land. So the actual property line is where the outbuilding wall is, and not where it's shown on the photo that was given.
I'm only able to comment on what's been submitted. I'm not aware of boundary restrictions or...
Can I come in on this? If it would help at all, that we accept whatever the landlord and tenant, whatever the land registry line is, as being the red line. The document you're referring to is an aerial photograph. It was just for the purposes of clarity. Wherever that boundary lies in land law, we accept, sir. That's fitted legal advisor.
Of the officer, yes.
When you were on about the music being played outside and inside and that, does that mean that music can still be played?
Yes, it does, yes. There was a de-restriction to the licensing of live and recorded music. I draw your attention to Appendix E of the bundle, set out in detail there. But essentially, yes, there can be no conditions attached or any licensing restrictions attached between the hours of 8 and 2300 hours. However, that does not mean to say that the licensing objectives cannot be breached, i.e. they must be upheld, the licensing objectives, and my colleague from Environmental Health will explain the position as far as noise nuisance is concerned. I think this might be helpful, should the licence be granted today, if there were issues going forward, there are environmental health procedures under noise nuisance, and there's always a view, obviously evidence-based, of reviews of licences. Hopefully that wouldn't necessarily be necessary, in which case a new visit to panel would be required, and that's a whole different scenario, which is probably not for today. Does that answer the question, sir? Thank you.
Does that clarify the position better? Yeah, thank you. Okay, no more questions then of the officer. We'll move over to Mr. Semper, who acts on behalf of the applicant.
Good morning, everybody. My name is Nick Semper from the Licensing Guys, and we're representing the applicant here today. The applicant is Mapplewell Bottle Shop Limited, here in the person of the director, Jonathan J. Ashton, and his wife, and Ashley, his manager from the Mirror operation that's already going on in Mapplewell. So what are we proposing? This Real Ale pub will be a replica of the model of the other successful operation in Mapplewell, which has existed for several years and has never come to the attention of any of the responsible authorities. The applicant has in this case, the applicant has taken a void premises and derelict piece of overgrown scrub at the rear and has invested significantly in refurbishing this eyesore, which was a blight on the surrounding landscape. This modern micropub will be a small pub where customers will enjoy an intimate and friendly atmosphere and partake in a select and high-end range of craft ales and artisan alcoholic beverages. Founded on the principles set up by Jay, these premises we hope will quickly establish an attractive and valuable contribution to the Denby Dale social scene. As you're aware, each application of course must be judged on its own facts and merits. The original operating schedule contained comment and context as to what was required, much of which could not be included as conditions attached to the grant of any licence. So on Friday of last week we submitted a revised operating schedule which is before you today. That is this document here. The significant merits of this revised application is that it is a quality application, correctly conditioned with specific, appropriate, proportionate control measures, thus minimising any potential that any licensing objective could be undermined. The second development is this. Your bundle already explains that since the Live Music Act of 2012, it's been amended a couple of times, all live and recorded music and unamplified music within the confines of a licensable area of a licensed premises between the hours of 0800 and 2300 hours to audiences of less than 500 are no longer licensable activities. We therefore remove all requests for any form of regular entertainment on this application. This leaves only the matter of on and off sales before you. The proposed maximum opening hours of this micropub are Sunday to Thursday, 10 in the morning until 11 o'clock at night, extended until midnight on Fridays and Saturdays. The 24/7 supply of alcohol simply permits on sales of alcohol to occur, for example, via an online portal of these bespoke and artisan ales, and no collections or deliveries can take place outside the hours of 0800 in the morning until 2000 hours at night. Now, in this hearing, the burden is on the applicant, i.e. Jay and myself, to show that the proposed operating schedule, the proposed operation, supported by the proposed operating schedule, is capable of promoting the licensing objectives and will not undermine them. Any representatives opposing this application have the burden to show that these premises, trading under the operating schedule before you that appeared on Friday, will undermine the licensing objectives and must demonstrate that with evidence. In our submission, any subcommittee properly advised could only refuse this application if it is found, on the evidence of the representatives, to be not capable of promoting the licensing objectives. So you may ask yourselves, why do the representatives, aka objectors, need to produce evidence? That is found in para 9.43 of the section 182 statutory guidance issued by the Secretary of State, which clearly states that, and I quote, this is a quote, the authority's determination, i.e. your determination today, must be evidence-based, justified as being appropriate for the promotion of licensing objectives and proportionate to what is intended to achieve. Significantly, there is not a shred of evidence before you today which challenges or criticises in any way the operating schedule, albeit its late arrival, the premises themselves, the applicant, or the designated premises supervisor whatsoever. There is no history of disorder, noise complaints, or indeed any other cause for concern evidenced involving these premises or this applicant or any other premises operated by this applicant before you. That is an undeniable and indelible fact. So let me first walk you through who has, or rather in this case who has not, raised any objection or representation. The licensing authority, here in the person of Mr. Butt, and being the lead responsible authority for all licensing matters in Kirklees, has made no representation. The police, being the lead responsible authority and source of expert evidence on all crime, disorder and ASB issues in West Yorkshire, they've made no objection. Trading Standards and Children's Services are the responsible authorities who protect children from harm. Public Health that lead on substance misuse, and Planning Department who lead on all planning matters, all raise no objections. This hearing is an evidence-based decision-making process. You, as a committee, cannot be insensible in my submission to the fact that only one of the lead and expert responsible authorities has objected to this application or has presented any evidence against it. You can therefore rightly assume that, in the opinion of the remaining professional and expert responsible authorities, this application does not undermine the licensing objectives. Otherwise, they would be here with evidence to argue vehemently against it, as is their statutory duty. Now, we've received a representation from Mr. Chapman in the Environmental Health Department. He observes that there is no extant planning permission currently on the premises, objects to the use of the outside area, and seeks to restrict the use of 10s on the premises to 3 per calendar year. Right, our observations on that are this, and we can go into much greater detail later if needs be, but just the overview. Para 14.65 of the Section 182 guidance clearly states that planning permission, building control approval and licensing regimes will be properly separated to avoid duplication and inefficiency. Therefore, planning matters do not sit before you and will be decided by the planning authority. Thus, in my submission, planning is not a relevant consideration. Secondly, as you already know, temporary event notices are not licences to be applied for and then granted by the licensing authority. They are in fact notices given by the applicant to the licensing authority and can only be resisted by the police and environmental health. There is no means nor mechanism in law whereby Mr. Chapman can limit the number of notices on a premises that this or any other applicant can give. Thirdly, and by way of reassurance, planning will be dealt with by Mr. Martin Parrish, a consultant from the planning group over there in Shrewsbury. They're a national operator, and the outcome of such discussions and negotiations will ultimately be decided upon by the planning committee. Rest assured, the applicant understands that, and although you may grant him a premises licence today, he will not operate outside the remit of any planning permission granted by the planning authority. Lastly, rest assured that this applicant, his wife and his manager have no intention of causing any of the consequences anticipated by the representations. We are left then with the objections from the local residents and neighbours. These, no doubt, come from good people. However, we must think hard about what they're telling us. To summarise, in a couple of sentences what they're saying, the first representative is concerned about the playing of live and recorded music at the premises, foul language, verbal disputes, litter and drunken persons accessing a disused path at the rear of the premises. The second representative claims that there are already too many licensed premises in the area, which they have claimed to be a total of 8, which we don't dispute, and there is no need for any more. They go on to claim that more alcohol equates to more crime, smashed glass and discarded food. They claim that there would be more noise in an otherwise sleepy village and unlawful parking on double yellow lines. And lastly, the third one simply does not want a beer garden at the rear of the premises, rat infestations from food left lying around, and loud noise from music and crowds affecting his neighbouring premises. The fourth representative echoes some of the issues raised by the others. Okay, now breaking that down. Need. Let me talk to you about need, or in this case, no need for another. It's addressed at para 14.19 of the Section 182 guidance, where it clearly states, and I quote, need concerns the commercial demand for another premises and is a matter for the planning authority in the market. This is not a matter for the licensing authority in discharging its licensing functions. Therefore, in my submission, the no need arguments are irrelevant in these proceedings. Secondly, all forms of regular entertainment have been expunged from this application. Therefore, issues of live and recorded music do not lie before you, as what we envisage is unregulated. In any event, we've already offered a noise management plan, which I'm afraid hasn't made its way into the bundle, but we've got copies here if you wish to see it, and a condition which states, this is the killer, no noise or vibration will emanate from these premises so as to cause a nuisance to neighbours. That is an enforceable condition which the responsible authorities can rely upon along with the neighbours to ensure that any noise is immediately dialed down. There's a further condition, offered on Friday, and what it says is this, that we will dial down any noise or vibration emanating from our premises immediately upon the request of a member of the responsible authority or anyone authorised under Section 13 of the Licensing Act. So those are enforceable conditions which the responsible authorities can rely upon, along with the neighbours, which ensures that any noise, if any noise were to occur from the premises, that would be dealt with fully, fairly and immediately, in the event of any complaint, of course. So we've got the crime, disorder and trespass. The main counter to these assertions is that A, the police are your lead source of evidence and professional judgment on crime, disorder and ASP, and they raise no issue with the application. And B, the model of this operation is already conducted by the applicant at Mapplewell, and none of these consequences have ever been realised over there. The matter of trespass on the disused, apparently impassable for 20 years, and overgrown path at the back of these houses is soon rectified by the provision of a substantial and impermeable boundary which will be provided in due course. As concerns noise and litter, this is not a late night venue, and our client avatar is not that of someone who would be attracted to noisy and challenging establishments. This is a micropub, not a sports bar, rock venue or nightclub. Customers will not throw their uneaten food around to encourage rats, nor will they be allowed to. It is simply not that kind of operation, and Jay and his team are not that kind of operators. Lastly, double yellow lines and car parking and car park enforcement. Put simply, these are not matters for the licensing subcommittee. Okay, I could give you some stuff about that, but I think you're experienced enough to realise that car parking is not, it doesn't speak to any of the licensing objectives. Okay, lastly, I want to address you very briefly on fear and speculation, if you'll allow me to talk to you on that for a matter of a few minutes. The representatives speculate that were you to grant this licence, then they fear that there may be problems. There are two main reasons why fear and speculation are not admissible in its proceedings in my submission. Firstly, para 9.43 of that 182 guidance I've told you before says that your decision should be evidence-based. Fear and speculation about what might or might not happen at some undisclosed point in the future is what it is. It is not evidence, it is fear and speculation. And secondly, there was a ruling in the case of Daniel Thwaites and Wirral Magistrates Court back in 2008 in the Court of Appeal, where the judge, who was Her Honour Justice Black, in her judgment, she indicated that your decision making should be actuated by, inverted commas, proper and real evidence. There is no history of problems at these premises, nothing before you from the responsible authorities save environmental health, which is mainly planning based, and the potential for any such issues is more than properly addressed in the proposed conditions. In any event, Parliament has already provided a mechanism to deal with future problems emanating from licensable activities at these or indeed any other premises. That is the premises licence review given to you by Section 51 of the Licensing Act 2003. You'll be more than familiar with it. I've appeared in this building before regarding Section 51 reviews, and you are never scared to implement your powers in Kirklees to address errant premises. So were you to grant this premises and problems were to ensue, and we're telling you they won't, but you know that's only our word for it, then the mechanism to control them is self-evidently provided through the aforementioned Section 51 review process. So I will rest now with your permission and deal with any further questions or queries in summary, but ask you to look favourably on this modest and well-conditioned application from this experienced and issue-free operator for this reassuringly expensive micropub. Thank you very much. Thank you.
Thank you. We'll move over to some questions. Could you tell me a little bit more about Mr. Ashton's experience? I think I've seen somewhere in here about...
I think your question is best directed to Mr. Ashton, ma'am.
Mr. Ashton, can you tell me about your experience, please?
So, well, events backgrounded, but then in 2019, occupied a redundant premises in Mapplewell. It was a photography studio just before that. Initially as off-trade only, and then during COVID, so I was doing home deliveries and people wanting to come out for more experience, kind of experiences, you know, changed the planning and the licensing to allow for on sales, which so was sort of like 50% bar, 50% shop, and it's been very well received. I will say initially, you see, we did some on events using temporary event notices, so that went off, fine, and was able to build trust and confidence. And yeah, there's been never any trouble with police or council. I do have a letter from a local councillor in Barnsley backing that up if you want to see it later, and also a letter from some neighbours that live directly attached to it as well, so backing that up, and also a letter from the guy who will be living above the place in Denbydale should it go forward, also in support, should you want to see that. But yeah, I think that covers it.
Okay, thank you. I want to understand a little bit more about the offer. What is the business? What is it about? What are the opening hours? Custom? I mean, I know I'm throwing a load of questions out there, but I want to understand a lot more about what you're hoping to put out there. What sort of business will it be?
That's okay. Well, I'll talk a little bit about what a micro pub is then, just to give it a bit of context. Because the microbar industry has grown over recent years as more traditional pubs have closed. Because smaller venues have got lower running costs, which means they're better positioned to weather difficult market conditions. So the primary focus is serving unique local beer and ales, and the sort that you won't find in run-of-the-mill chain pubs, often sourcing drinks from independent microbreweries in the local area. This also tends to attract a more discerning customer. The product on offer and the price point can be a natural filter. Most micro pubs serve only bar snacks, but instead focusing on serving quality beers, ales and artisan spirits. Not cocktails, no shot bombs, baby Guinnesses, anything like that. They're intended to be spaces for conversation and socialising over a drink without distractions such as loud music, TVs or fruit machines. These small spaces often a lifesaver in small villages and towns that have lost all of their pubs, providing a sorely needed space to socialise and sample a few quality ales. One of the breweries, for instance, that I plan to have in there as a permanent line is from a little brewery in Penistone called Woodland Brewing. So that supports their business as well. So the economic benefits can be quite far-reaching.
So can you tell me about, for example, your opening hours? So you've asked for this license, which really in effect is a 24-hour license. So I'm assuming you're not going to be opening 24 hours.
Mum, yes, you're absolutely right. The 24-hour, that is often very confusing. On these forms, it's hard to specify the difference between on and off because they're in the same times. He would like, especially, in fact, I received a government briefing not so long ago, and we have to write every licence going forward as being COVID-proof. Okay, and therefore, when we ask, so we put on off licences with the provision for off sale and also for online sales as well, in case COVID ever comes back, because we were very much as a nation taken by some antiquated licensing laws when it happened. So, what he wants to do with a 24-hour licence is to be able to run a web shop so people can place orders and have it delivered between 8 and 8. You'll see the time for collections and deliveries is limited to 8 till 8. However, his actual opening to the public hours are as specified within the application, ma'am. It's, remind me, it's 11 o'clock closing on Sunday to Thursday and midnight on Fridays and Saturdays. Okay? Does that help at all?
Yeah, that helps. Tell me a little bit about your custom. Where you're hoping to get your customers from? Is it local area? Is it people will travel to where you are? Can you give me some more detail about that, please?
So one of the reasons why Denbydale was, I've got some customers in Mapplewell who do travel over from that way, and the locality in Sisset and Shelley, and they're like, oh, can you open one in Denbydale? Or would love to have something like this in Denbydale. And when I saw the newsagents was available, I could sort of see that vision becoming a reality for some. And actually, there is one guy who's bought a house that's being built, you know, sort of up the back in a new build, hoping that I'll open, because he's moved from Mapplewell. And
tell me about the support from the neighbouring premises, please. Across the road.
Oh, and the people at the White Hart. Yeah, the people at the White Hart have expressed their support, you know, thinking that we can work together to keep people in Denbydale, because I know for a fact that a lot of my customers who, you know, can sort of, well, us, we've got the craft beer and also, you know, traditional hand pulled on, they go off to Home Firth and to like Tipsy Cow at Skelmanthorpe, which I don't want to take any business away from them, but I feel that there's quite a lot to sort of go around.
Ma'am, when it comes to ideal customer avatar, it's quite ironic, because the gentleman sitting over there are exactly the type of people he appeals to, ma'am.
Okay. So I've had a look at, obviously, the application, the map in particular, about what the offer's going to be on the ground floor and on the first floor. So I'm wanting to know a little bit more about capacity. How many customers do you think on average you're likely to have, and what the capacity is? But also, as well as alcohol, will you be serving food?
No, there isn't room to prepare food on site. There isn't the space. As I mentioned earlier on about micro pubs, concentrating on the beer ales and artisan spirits, we won't be preparing food on site. It'll just be pre-packed crisps and snacks.
Ma'am, as you know, capacity is set by the Fire and Rescue Services as part of the fire risk assessment and their assistance. We're some way from the building being finished yet, but if Jay were to talk you through the plans, and he can tell you what he's anticipating on each level.
So it's relatively low capacity because we don't want everybody to be too hemmed in. But so, as you've been to the site, you'll realise that the building is on the side of a hill. So you're actually walking on, let's call it level 0, at street level, where you'll walk in, and there's a few seats there in the window opposite, a few more seats in an L, and the main bar. The back here is going to be the cellar, back room. As you can see, there's plans to be an accessible loo there on that level 0, and then a staircase to go downstairs to what I'm calling level -1, because that is the area that then opens up into potential beer gardens. So if you're looking at this picture, it's like half of the downstairs area here.
It just occurs to me that they've got black and white versions of this plan. Is it okay if I come forward and provide you with a colour one which really sets the whole thing in context?
Yeah, so we're talking about maybe another 20 people downstairs inside the building, with another couple of loos. Outside, we're looking at maybe half a dozen tables, so potentially 20 people seated, max.
That's only in good weather and
yeah.
Particular times of day.
Sorry, is that the front of the building?
So, sorry, that was downstairs at the rear. At the front of the building, there is that's a good point, there is that little strip of land where there's capacity for about 4, just the little round bistro tables, the design of which is in that pack there as a little idea. So there could potentially be 12 or 15 people sat out there, but I've just got to judge space on that, you know, when we're there. It might be less.
I presume that's something that planning will be looking at and considering when that time
I would
comes.
expect so, yeah. I want it to be comfortable for people, you know, I don't want to...
I've got a few more questions, but I'll let my colleagues come in. Councillor Ryler?
Thank you for all the information that we've had so far. Can I ask, will there be any security personnel employed? And how will you actually manage the noise if there is an increase in noise level, particularly outside, but maybe inside as well? Thank you.
Right, ma'am. This is not the kind of premises that we would anticipate needing an SIA element. We not expect our avatar, our experience at Mapplewell and our licences up and down the country. This is not bit where people go for a punch and a pint. That's the sports bar kind of end of the market. Now, look, unfortunately, and there's been a lot of chop and changing at the end of this process, but we have actually served on the licensing authority almost at the beginning, the noise management plan, but unfortunately it's not made it into your bundle. So if I can slide across a copy of it, ma'am. Hello? There's the noise management plan, and that's Jay's first sort of draft of that. What we're after, it sets up how we will manage that plan, manage that noise, and you've already in the condition. So it's a condition as a noise management plan anyway, but it also in the revised operating schedule, you've got the conditions that design out and address any possible noise issues as conditions which are legally enforceable, as you're aware. So I think we've got the noise. I think we've got the noise addressed, ma'am, to your satisfaction.
No, that's very useful, thank you. No more questions.
Councillor Davis?
Thank you, Chair. I'm keen to explore sort of like we've had questions about the customer and the offer, is like the setting of the background area. I know there's some lovely pictures in here of garland lighting, pergolas. Yeah. Can you describe your plans for that back area, please?
Can we have that document back, please, ma'am? Because there is a plan of it, indeed. Where's the plan of it? Have we got a plan of it? Okay. Right, you're right. There is no actual layout of the garden at the back. The garden at the back at the moment is scrub and rubble and scree and what have you. He's told you that he intends to have some picnic benches out there. That is going to be a very, very weather-dependent operation, because people don't sit outside in the rain unless there's heaters and what have you, and there's no immediate plans to do that. However, please rest assured that whatever goes on in that backyard, as concerns the layout and plan of that, will be in complete accordance with the planning authority, of whom Environmental Health and the rest of the responsible authorities and many more local councillors are all consultees. Ma'am.
Thank you.
Okay. So I just wanted to sort of explore a little bit more, especially around the seating outside, at the back and the front. And I think there's two objectives that talked about protection of children from harm. And it isn't something that you've sort of addressed, I think, in your representations. So I want to understand, you know, how are you prepared to at least make sure that children are protected?
Right, okay. As concerns licensable activities per se, the protection of children from harm is dealt with in the revised operating schedule, which I think I may have delivered up there. Okay. As concerns, there it is. as concerns other risks to children, if you can be specific, ma'am, as to what you're anticipating the threat to be. I mean, you've got people sitting. I think it may be the bistro chairs. The bistro chairs outside, our children going to be abused by our customers as going to and from school. We don't intend to be open at school opening time in the morning, and the hours we've asked for are an envelope. They are parameters, but really the amount of people that want to be using our place at 3:15 when the primary schools are tipping out and what have you are going to be few and far between. Okay, the other thing is this. The place is bristling with CCTV. If there are problems, we do not want customers that upset children on their way to and from school. Okay? We don't want customers that might give kids a sip of the beer when they're walking past the bistro tables. That's not the business model. And I'd point you to the Mapplewell outfit, and we've got the management here if you wish to put questions to them. But that's not been our experience. That's not the kind of customer we're after. And were we to find it, then it would be dealt with firmly, fairly and immediately, because that sort of behaviour can prove fatal to what he's trying to propose here. I mean, they just would not tolerate it, but you may want to hear from them themselves. Thanks.
Yeah, I'll just say that we actually have a sort of guideline between us that come 7 o'clock, we look at having children off site so that they're not subject to, if lips get a bit loose or something, later on in the evening, because and I personally, leave it. That's it. That's the way we have in place.
The last question I sort of wanted to explore is about light pollution, and I know Environmental Health are here, and they'll talk us through their report, even though there's been a proposed amendment, which I'm sure will seriously impact on what Environmental Health have to say. But they have put something on page 52 about light pollution.
Yes. Oh, yeah. Fair one. Right. You've got to be. It's difficult because I don't want to attack my good friends from Environmental Health, and there's certain things within Mr. Chapman's report that I fundamentally don't agree with. So without going through all that, if I were just to for example, there's stuff about odours. We're not going to cook any food there, so it's I don't know what it's doing there. But again, I don't want to personalise it. So on the bit on light pollution, as concerns light pollution, what I say is this: although we believe it is unnecessary, we are prepared to accept the condition that all external lighting should be directed so as not to cause intrusive illumination or glare to neighbouring premises, businesses or road users. I mean, frankly, the thing speaks for itself. We've got no intention of setting up spotlights to glare into these people's homes. But if Mr. Chapman wants it on there, it's actually no skin off our nose because we were never going to do it anyway. Okay? Thank you.
I think, to be fair to Mr. Chapman, who's not here, his colleagues here, I suspect the reason why they've drafted this report the way they have is in the event that that's something that you intend to do in the future. Sell food, lighting. I mean, Environmental are here, so they can explain it, why it's particularly in the report. But for me, I understand why it's here. It's it's protection for the future. Okay? Right, okay. Licensing officers, any questions for the applicant?
No, thank you.
Right, I'm going to move over to the objectors, whether you have any questions. Could you just confirm your name if you are going to ask a question first, and then put your question, please?
My name's Andrew Kellett. We have no objection to Mr. Ashton opening a business. We have an objection to the use of the space at the back as a beer garden, because it backs directly onto our properties, and if, like Mr. Ashton says, he's going to have half a dozen tables out the back, that's 20 to 30 people can be sat out there consuming alcohol. The volume is going to go up and up, and it renders our back gardens useless to use for relaxation and everything. My neighbours directly up from us are all pensioners in ill health, and we're only 12 metres away from the background.
We need a question. Is there a
Sorry,
question in there?
right. What's the question now then? Because I've...
While he's just putting that question, with respect to that,
Should we let him ask his question?
Yeah, okay.
To be fair, he's listened to you. I presume the question's around how the noise nuisance is going to affect you and how they're going to
Yes,
mitigate.
it is. It is how is going to deaden that sound. Is there going to be a physical barrier put up, or are you going to monitor the people that's out the back, or lessen how many can be sat outside?
I spoke to a lady, I don't know which house it is. I think she lives next door to you, George, or anyway.
Do you know her name? I could...
Oh, I can't, no.
But anyways, give them the reassurance.
She's not here.
But anyway.
She's not here at the moment.
No, so anyway, we had a chat about putting a 2-metre fence up, you know, butting up to, there's a bit of a hedge there at the moment, you know, putting a 2-metre fence up there, which she seemed keen on, along with the neighbour in the bungalow, seemed keen on that idea, and replanting another hedge around it as well.
The question is that what you're proposing to do then?
Yes, absolutely, yes.
Okay, do you have another question, Mr. Kellett? That's coming. If not, I can turn to one of the other objectors. Any questions?
Thank you. In the revised operating schedule, you mentioned CCTV systems will provide clear images inside and out. Will these cameras be capable of capturing audio or video of private residences in any way?
No, in a short answer, because the Information Commissioner's guidance on the use of CCTV does not allow the surveillance of your private areas.
There's no possibility then that the microphones on the CCTV would be sensitive enough to capture people in their back gardens 15 metres away?
No.
The revised operating schedule again, it says general consideration to the respect of neighbouring properties. What does general consideration mean?
What it means, exactly what it means, sir, will be to consider as neighbours.
In the revised operating schedule, you reference noise-sensitive receptors. Could you just clarify exactly what that means, please?
Yes, but I think that's best placed with environmental health. There are. What it means is that it is a premises that is noise sensitive nearest. So, a warehouse that is not occupied is not a noise sensitive receptor, but a dwelling house that is. Okay, but there's a technical. We're getting into technical EHO land here, and we have a very experienced environmental health officer who can advise us.
You also say, so as to cause a nuisance. What definition of nuisance are you using?
Right, that's a good question. A very good question. Public nuisance is defined in the Licensing Act, which is what we're discussing here, as noise, light, infestation, litter, and something else. It'll come back to me in a minute. I think it's in para 2.1 of the Section 182 guidance. However, as concerns the other form of nuisance, that's statutory nuisance, and that is defined by the Environmental Protection Act of 1990, which this lady will be very, very familiar with, because there's all sorts of machineries and powers that come with that about statutory nuisance as opposed to public nuisance, which is very loose and weak in the Licensing Act, and that involves a graded, graded intervention from advice through to noise abatement notices, and then prosecutions, criminal prosecutions.
So there won't be a sort of voluntary limit. You will be sort of sticking exactly to sort of the legal statute of what you can and can't do.
We will be sticking exactly to the letter of the conditions that this fine panel hands down to us today, sir.
Obviously, we've talked about the proximity of the drinking garden to residential properties where families live with children. How would you prevent patrons who have had a few drinks from swearing within earshot of children? How would you enforce that? Because that would be, I think we can agree, a risk of harm to children, surely?
Yes, indeed, and the client, the applicant has already explained his posture towards bad behaviour in his pubs, and were somebody to start swearing and causing a problem, let alone to the because obviously it would be to the other customers first, and there'd be the children in the bedroom a distance away much later, I would venture to suggest, due to the distances and proxemics, he would put them out the door, sir, because we are not, those kind of customers are not welcome in one of his pubs.
So to clarify, then you would have a free strikes policy, something like that. So if somebody says once,
we're not making policy on the hoof here. I've told you what the posture is, and it's zero tolerance towards bad behaviour and drugs. Now, how individually maybe somebody is capable of accepting advice on a first strike, and that is the end of it. They apologise unreservedly. Maybe somebody wants to go round two. Each must be treated on a case-by-case and dynamically risk-assessed basis. Our posture, our position is we adopt zero tolerance to bad behaviour in pubs and substance misuse.
No more? Thank you. Okay. Mr. Froggatt, any questions? I just have one more question about your tenant upstairs. Is it a tenant that's upstairs?
So I'll be leasing the building, and Roy's had, there's a flat above that. He's been there a number of years.
So he's a sitting tenant then? He's okay. And you said this tenant's in support of your proposal? Okay.
So just, yes, in case the audio's been, nod's not very good, is it?
All right, thank you. So moving on to the objectors. So we have Environmental Health here with us, not Mark Chapman, but his colleague. Could you just identify yourself, please?
Hi, yes, I'm Alexandra Gary. I'm a Senior Environmental Health Officer in the Pollution and Noise Control team.
Lovely. Can you make your representations? Thank you.
Yeah, basically we don't have objections to the business per se. Our concerns are regarding the use of the outdoor area to the rear due to its close proximity to a number of residential properties. Obviously there's been a change in your application with regard to music, but we still have concerns about the potential for intrusive levels of noise from customers consuming drinks in that outdoor area, which is quite a difficult noise to control, and it cannot be regulated or mitigated easily to prevent potential noise nuisance. Obviously, any music isn't covered by the licence, but there is still potential for any music that's in that outdoor area to potentially be a statutory noise nuisance as well and result in a loss of amenity to the residents nearby. And it's on those grounds that we are objecting to the outdoor use to the rear of the property.
Okay, thank you. So just to clarify for myself and everybody else in the room, irrespective of the fact that the applicant has amended the application to say there won't be any live music, indoors, outdoors, any recorded music, your position's the same. You're objecting to the application.
Yes, we are purely on the fact that there is still the potential for noise nuisance from customers in that outdoor area.
Or are they just objecting to the use of that rear yard?
Yeah, to clarify, our primary objection is to the use of that outdoor area to the rear of the property.
Okay, when you say primary, are you, it's a really bold question, are you objecting to the application, the licensing of the entire building, or is it just the backyard?
Just the outdoor area, yeah.
Okay, thank you for that clarity. Cheers. To the rear.
Thank you. Can I clarify, I mean, I know you've said to the rear, what about at the front, which is also a proposal?
That is a potential, but because of the use of the road, we don't see that as a bigger potential to cause a noise nuisance to residents.
Okay, thank you. Right, I'm going to move over to my colleagues. Councillor Riley, any questions for environmental health?
Yeah, just to clarify, in terms of the noise, the new noise management plan, I guess you've seen, you haven't seen that, no, okay.
It was, honestly, man, it was it's fine.
So it does say that live music at an acceptable sound level and to cease at 8 p.m. And a noise curfew of 10 p.m. On any given day. I mean, it does say lots of other things then as well. So I'm wondering whether the new information might affect your decision making.
Again, if they're having outdoor music, that is still a reason for us to object.
Is that independent of the time?
Yes.
Thank you.
Okay, Councillor Davis, questions? Okay, so this is a question really for the applicant. Just bear with me a second. This is a question for the applicant because I think this is kind of integral to, you know, why we're here and why we have difficulties in getting it over the line. So we've heard today from, and we've heard today from, well, we haven't fully heard from the objectors yet, but we've seen in the application that there's an issue around noise levels, which causes concern to environmental health, and it causes concern to the objectors. And what we're sort of interested to know, because you haven't really answered those questions, and I think it's important to get some kind of answer and clarification. Because there's difficulty controlling potential noise nuisance, do you have any suggestions, any policies, any conditions you think that you'd like to put forward that might mitigate against
Yes, ma'am.
noise nuisance?
Yes, ma'am. We have the noise management plan built into the conditions. Okay? We have the overarching condition that no noise or vibration may emanate from these premises so as to cause nuisance at the nearest noise sensitive receptor. And we have the condition that in the event that EHO or the police do turn up and saying it's too noisy, we're getting complaints, we will turn it down, dial it down, whatever is going on down there, immediately. Okay? So those are the safeguards and the guarantees that will become an integral part of this licence.
So is that the document that you've passed over to my colleagues? Is that the document that you're referring to?
Yeah, it's something slightly different, but it's okay.
Right, so I need to get some advice from the legal officer about considering this at this very late stage.
It was already served on the licensing authority. Unfortunately, for whatever reason, it didn't come through. These things happen. It's okay, we've got time to put it wrong.
Thank you. So we obviously need an opportunity to have a look at this in conjunction with the application that's been put in. I don't think we'll have a chance to do it now. We'll probably have a chance to do it and get to discuss it a little bit later on. Thank you. Okay, so questions for environmental health applicant?
I've just only got one question for the lady. Can you confirm or deny that loss of amenity is an argument for a planning authority and not a license and matter for the Licensing Act of 2003?
We use the term loss of amenity, but it is the same principle, that the issues with what we're concerned about, the noise from customers, is going to affect the residents nearby.
Okay, it's just going to be really rude and I don't want to be, but can you point to the Licensing Act where it refers to loss of amenity, please?
I can't, no.
Okay. So we'll move over to the objectors then. Start with the gentleman there at the end. I think it's Mr. Froggett. Do you want to make your representations?
Yeah, okay. As Mr. Kennett said, in principle, we're not against the actual shop opening. I think the thing is, it's sometimes you can quote bylaws, and you can quote rules, regs, and what have you, but it's a bit more nuanced to me than that. Sunnybank, at the other end of Sunnybank is Norman Road. On Norman Road, there's a social club. So I only live a few doors down from that. And admittedly, when we bought the house knowing full well that that was there. But you still have the issue sometimes with noise. Yesterday in particular, with the Euros, I mean, they were outside and the groups were building. And so these are our issues. The noise, as they drink, the noise does accumulate. And the problem is that you may have rules or you may have things in place to try and counter that, but they happen, and it can be just a bit more nuanced than just saying, well, as soon as it gets loud, we're going to stop them. But once they start drinking, they're not talking to one another, they're shouting at one another sometimes. And then sometimes you've got the foul language. We can't sit on a summer evening when it's really warm in the house. And I assure you, Sunnybank gets quite warm, hence its name. Because in late evening, they're all sat outside and the noise gets louder. So, you sit with the windows shut. And so those are the concerns I have at my end, but they can be perpetuated with Mr. Kennett and neighbours that live next to, because the other thing that we're concerned with is just a transition people just walking past the back of our properties. The kitchen windows are on a sort of ground level. And, we're just concerned about, because that happens. And in recent years, I've had to fit a security camera to, because stuff happens, noise, what have you. In one case, we had eggs thrown at our window, but, that aside, those are the concerns we have, you see, regarding noise. But the noise does garner, it does get greater as the night progresses because they've drank more, and those are my issues and there are my concerns.
Thank you. We'll move over to the next gentleman. Is it Mr. Kellett?
I live directly behind the proposed beer garden. Myself and my two neighbours that are directly behind it are opposed to the beer garden because of the noise. It sounds as though music's still going to be played, so from 10 o'clock in the morning till 10 o'clock at night there'll be music in the garden, there'll be people drinking and swearing, lots of noise. Before we objected, my wife emailed Mr. Ashton with a few concerns, and his reply for the noise in the back garden was that he says, I've applied for outdoor background music until that time, which was 8 p.m, but at low incidental volume. The sound of people having a nice time will probably be more audible. So they're going to be over the top of the music, drowning out the music and causing nuisance. We are not going to be able to sit out in his gardens during the day because of all the noise that's come over the fence. What else can I say?
Mr. Buxton.
Yeah, Mr. Buxton and his wife are both ill. They enjoy being out in the garden, but they're going to have to go in because you're just going to have all the noise of the people drinking, just drowning them out. We're going to have windows shut when it's warm at the back to keep the noise out of the house. There's young children 15 metres away. The house next down from me, they've got a 12-month-old baby, they've got a 6-year-old and a 9-year-old. Same next door, they've got a 6-year-old and a 12-year-old. They go to bed at 7 o'clock, 8 o'clock on a night. They're going to have the windows shut because of the noise that's coming out of the back garden. And like I said before, we're not against him opening a business. It's just the concerns over the backyard with the music and the noise of people. If there's going to be 6 or 8 tables in the back, that's 20 to 30 people can sit outside and standing up as well. So there's going to be quite a lot of noise coming from people talking. And when they're consuming alcohol, the volume goes up incrementally as the day goes on. So that's the concerns about the back garden, the beer garden.
Thank you. Yeah, I'd like to just echo the comments from my neighbours. We're not opposed to the opening of the bar itself within the business. It'd be nice to have something like that in that building. The concern really is primarily around the use of the garden space. Mr. Ashton's mentioned that he'd be looking at 20, 30 people potentially, something in that range. 30 people talking at room level is roughly the equivalent of a motorway in terms of noise. It is. I've done the calculations, not to sound too smart about that. And that's the primary concern. The concern is that the noise that's going to come from this back garden, beer garden, is going to be disruptive to a significant degree, and that's the thing that we don't want. And I don't see any way of managing that effectively, because it's not about an individual person getting loud or drunk. It's about a collective ensemble of voices. And you can't go to a beer garden and say to your clientele, only one person gets to talk at once. Everybody will talk, the noise will aggregate, it will, group together, and that's an inevitability of 30 people, 20 people in a garden separated by a fence and a hedge. And while I appreciate the fence and the hedge being put up, I don't see any reasonable way, realistic way that a fence will diminish the noise from 30 people talking, even at casual room level. Yeah, thank you.
Okay, so we'll move over to questions. Go to my colleagues. Councillor Ryler.
Thank you. Regarding the outside space, can you describe any way in which mitigations could be introduced to make it amenable for yourselves?
I think there would have to be a significant limit on the number of people allowed in there to a degree that might be unpalatable. 5 people, maybe. That's not something that I can sort of speak to exactly. I don't know what 5 people sounds like versus 10 people exactly. But there would have to be a significant limit on the number of people allowed out there at any one time. Including as well fences and sound dampening where available, and then an absolute outright ban on music being played.
Just in relation to times, so would that be at any time that those would be?
I think there'd need to be a reasonable time limit as such. Midnight seems very late. 10 o'clock might be reasonable. 9 o'clock might be preferable. 8 o'clock might be ideal. I don't think it's any of us have got we absolutely want this and we won't budge an inch. It's just about communicating and sort of figuring out what a balance would be on that. But I mean, if I was getting exactly what I hoped for, 8 o'clock, but as I say,
Thank you.
Could I just say, in reference to your question there, because of the location or the proximity of my property to, say, the social club, so therefore the experience we've had, as a rule of thumb, we generally just settle down at perhaps around 9 o'clock at night to watch some TV, with probably a couple hours of TV. But again, in the summer days when it's warm or something like that, we can't sit there with the windows open just to vent the air, the house, to cool it down. We'd have to shut because the sound from the club would be emanating through, and my partner will just say, just close the window, So, even night, 8 o'clock would be great, but as for, how many people, I mean, outside the social club, 4 people can make quite a lot of noise, they stood around having a cigarette or vaping or what have you, and yeah, it depends how much they've had to drink at that particular time, because they're not talking to one another, they're sort of shouting at one another, if you get my meaning,
Thank you.
The layout of the building doesn't lend itself to deadened sound either. It's like a U-shape building, so all the sound is going to hit that wall and come over the houses on Sunnybank. There's no way it's going to just dissipate. It's going to echo a bit round, so it's going to amplify the sound, is the structures around it as well.
Councillor Davies?
Thank you. So just to clarify again, so you've said you're not objecting to the business, it's the noise. Is it the noise at all times of the day or just later into the evening?
We like enjoying our garden during the weekend because we work and everything, but we don't want to sit out there and be drowned out by music constantly all weekend from 10 o'clock in the morning while 10 o'clock at night. There's music going to be playing, there's going to be people talking and shouting. So you can't sit out and enjoy yourself and sit and just enjoy a cup of tea or something like that and enjoy your garden, because you're going to have all this noise that's wafting over you all the time, constantly. That's why I'm objecting.
Okay, so I'll move over to, I think, licensing officer. Any questions for the objectors?
No, thank you.
The applicant, any questions? So you'll have an opportunity, once you've asked your questions, to address what's been said and make representations based on what the objectors have said. But any specific questions?
I know. There's nothing we won't be able to deal with in summary, ma'am.
Okay, so the next part here then is for the applicant to address or respond to what's been said.
It's a summary now, yeah? Okay, right. Yeah, I'm just very conscious of your time. I'll have a whiz through, I'll have a quick blast through. Nuance. There's some really good points raised over there. We want to work with you guys. You're our neighbours. We don't cause you any problems, okay? Being at war with you clearly be very bad for the business model, let alone any other reason, that we don't want to cause you problems, and we want to invite you and your families into our premises to enjoy and support us. Right, the first thing, nuance. I get the point you're making on nuance. However, we are here in the business of writing black and white conditions which will promote and will not undermine the licensing objectives with the help of the legal advisor here. There is nothing nuanced about conditions that are well read, are well written, and then properly enforced. Okay, it sets in stone the behaviours going forward. We've heard about noise from events down the road at this club or whatever yours. There is no TV or Sky TV going to be put in at these premises. There's no going to be a big roar when anybody scores in the Euros. Okay, late evening. We've been talking about late evening and all this noise is going to be going on late in the evening. We've already said that the garden is put beyond use at 2,200 hours. Somebody's mentioned 2,100 hours. I will leave it to the wise panel as to what they think is reasonable, but if you want to meet us halfway at 2,100 hours, ma'am, sorry, if you would like, I looked at the wrong person then, I meant to look at you. If you're telling us it's 2,100 hours to get started and to see how we all get on and whether we can all remain friends, absolutely fantastic. Transient people trespassing in this lane. We can't, it's nothing to do with us. He hasn't even started yet, okay? But I can tell you, with respect, I can say this. There will be no access from his premises to that lane. So anybody trespassing down there will have had to scrambled over his substantial boundary, impermeable boundary that will be agreed with the planning department in the future months. Loud music. There is no loud music. Well, what they're talking about is background music in the part of the licensing, in part of the noise management plan. Background music is to set ambiance. It's not even licensable. Okay, a couple of little speakers, a little bit of soft music and what have you of an evening. Not even licensable. What we're talking about is live and recorded music, albeit it's not even regulated entertainment. With respect, we cannot seek to regulate matters in this room which are simply not regulated matters under the mechanism of the Licensing Act. However, we have already putting the yard beyond use after 2,200 hours, 2,100 hours at the chair's discretion. There is not going to be loud music playing from 10 o'clock in the morning till 10 o'clock at night. That is not envisaged at all. Okay, we have some fear and speculation, I'm afraid, about people having to keep their windows shut. They can't use their own gardens. Children and babies can't sleep. Constant music is going to be on 10 until 10. That's not going to happen. And were it to happen, we'd be back in this room under a Section 51 review, and this lady and her team would be taking the licence office. Okay, that is not going to happen. Please be assured. Right, okay. I'm sorry if you saw me smile about the 20 people in a room talking as loud as a motorway. I'm awfully sorry. I used to be the commander, I used to be the section leader for a traffic department on a motorway, and honestly, the trouble I'd have to go to ensure the personal protection equipment for my teams working on the motorway to avoid noise-induced hearing loss. I assure you, a few people talking at a pub does not equate to working on a motorway, in my personal experience and in my submission. That is why I smiled. I'm sorry if I offended you. I'll deal with the rest in summary, ma'am.
Right, okay. So it looks like we're coming to the end. Okay. Normally at this stage, we'd get everyone to sum up to deal with the salient points that you want the panel to particularly take away, and consider when we're deliberating. I think Mr. Semper. Okay, so I've just got a quick question for Mr. Froggett about the representations that you made about living next door to, was it a social club? Yeah, and that you've had some issues in the past with noise nuisance. Have you ever reported that to environmental health? Just interested to know the context.
No, we haven't. It happens intermittently, but you get it, I think basically we resigned ourselves to it happened, if it got to a stage where it was really, affecting our life, we do that. We appreciate that, people do have a drink and they can get loud, but it is a factor that's what happens, when a group of people meet and they sit outside. There's no, in terms of the point about the Sky TV, there's none of that. It's just people in general stood outside. There's some tables and wherever they're drinking, and they've, some of them have been there for a good few hours, and that's it. Yeah, maybe I should do. Maybe I should report it. I mean, I don't know about this morning because I haven't been around the corner, but I could expect that there'll be lots of glasses and bottles and stuff like that, on the wall of the, that's sort of pavement side facing. But, that's just a separate thing anyway, yeah.
That's really helpful, thank you. Okay, so summing up at this stage, we give everyone the opportunity to sum up and leave us with the salient points so that the panel can consider what decision we want to make. Okay, so we'll start with the licensing officer.
Thank you, Chair. So we have before us the application for the premises that we've been discussing at Denby Dale. The licensing hours have been outlined. The regulated entertainment, which had been submitted initially, we've had a revised application submitted, which means that part of the application is no longer regulated entertainment. It's not an issue. However, we have had the conversation to say that it is allowable between the hours of 8 and 2300 hours. We've discussed that the sale of alcohol, albeit on paper looks to be 24 hours, the opening hours are far lower than that. I think it's 11 o'clock. And the reason for that is that they want to have on sales. The primary reason of concern from the objectors, which we have here, both from residents and environmental health, seems to be the use of the outside area. We spent length discussing that on both sides. The applicants put forward the application and given their mitigation and their reasonings and their business model has been looked at in some detail. We've discussed what options are open to the panel in terms of what can and can't be done with regard to the licence. Excuse me. Environmental health have discussed what noise nuisance is and what mitigation can be acceptable. There has been a noise management plan put forward. I will make apologies, it was submitted with the application. That is an oversight on the licensing department. But that has been looked at this morning and it is there for everybody to see. I think that really sums up the licensing position here. Thank you.
Thank you, ma'am. Right, dealing with environmental health in summary. Mr. Chapman, in his original representation, and it's been echoed by his colleague here today, has the opinion that there is a potential for intrusive levels of noise from customers using outdoor space at the rear for drinking, which in their opinion could be uncontrollable. To that I say, it is. Potential noise from customers is indeed entirely controllable in 5 ways. Firstly, we have the limited use of the back garden until 10 o'clock, and you may wish to dial back on that, as we discussed before. There will be a noise management plan. This is a living document. It changes. It is made available at immediately at request of environmental health when they come knocking, I should say, sorry. And where there are inconsistencies or it wasn't clearly working, then they have their enforcement powers to engage us with. 3, a substantial boundary fence is to be erected between these premises and a neighbouring premises. 4, we've conditioned a licence to say that no noise or vibration shall emanate from the premises so as to cause a nuisance. We've done that to death. And lastly, we will respond immediately to any request to reduce any such public nuisance noise, i.e. on the request of the police or any member of the responsible authorities. Okay, so that's my way of countering that theory that it's uncontrollable. This hearing, in summary, is simply about whether this new, smart, quality, yet modest establishment operating these hours in accordance with this operating schedule as amended and the noise management plan is capable of promoting the licensing objectives or whether it will undermine them. Very clearly, our position throughout the morning is that it will not undermine them in any way, and all the responsible authorities, with the exception of environmental health, have now zoned down to the use of the rear yard, have raised no issues with its substance, content and additional inbuilt safeguards. There is no recorded history or indelible evidence of noise nuisance. Now, thank you, we found out from the location itself, or from pollution, safety, ASB, drugs, crime and disorder issues with the operation of these premises, or indeed any other cause for concern evidence involving the application, the applicant or any other premises that he's been operating in Kirklees before you. That is an undeniable and self-evident fact. Consequently, I respectfully request that you do indeed grant this licence as sought, supported by the comprehensive raft of effective conditions and any others, ma'am, and your team, your panel, that you deem appropriate and proportionate. Everyone is welcome at this new business. The panel members and the neighbours and the residents, everyone is welcome. So let us wish Jay and his team every ongoing success going forward with this new and welcoming establishment, which will prove to be nothing but an asset to Kirklees in general and to Denby Dale in particular. Thank you very much indeed for your time.
Okay, over to the objectors. Do you want to start first, Mr. Froggett?
Yeah, I'll just say that, again, we'll just reiterate, we're not, opposed to the actual setting up of this shop, of this business. Again, our concerns are relating to that yard space at the back. To some degree satisfied my concerns about transient people walking past, although that remains to be seen, whether people do take a shortcut, even in error, to try and access this premise. But we're still, for the benefit of the neighbours that aren't here today, particularly because of ill health and that, and because of their close proximity to it, it's still, I feel it's still a bit of a sticking point for me that the proposed use of a beer garden or a social area at the rear of the property. Okay.
Thank you. Mr. Kellett?
Yeah, as Patrick said, we're not against the business. It's just the use of the backyard that's going to affect our lives, really. It was never meant to be a beer garden or anything like that. It was a little parking spot for the shop, and when it was a council office, and I just think it's going to impact our way of life, really, to enjoy our gardens. That's all I need to say, I think.
Mr. Lodge?
Thank you. Yeah, I agree with my neighbours. Again, the application to use the building as a bar is not really disputed. The concern is that the application that exists today is untenable from our point of view, which is the use of the garden as Mr. Ashton has hoped. And we've heard good intentions, and I think we accept that those intentions are true, but intentions and reality often don't align, I'm afraid. And as such, we object to the application as it is presented today.
Environmental health?
Thank you. Despite the applicant's assurances, we still consider that there's a real potential for intrusive levels of noise from the customers consuming drinks outside, and also noise from recorded or live music to be a potential for a statutory noise nuisance. So we will prefer the external rear yard not to be used for licensed activities.
Okay, so thank you everyone. So we now need to consider what we've heard. Just bear with me a moment. Okay, thank you. So the legal officers just asked me to clarify some important points for us to consider in the interest of fairness. Okay, so in terms of the representations that you've made in relation to potential intrusiveness of using the space outside, could you provide some evidence on what basis you're making those representations, please?
We do deal with noise nuisance cases across the borough. I have a particular case at the moment where there is a beer garden in very close proximity to residents, and the levels of noise there have resulted in an abatement notice being served on the licensed premises, and it's that situation that I want to avoid in these circumstances for the residents, because the noise has not been able to be controlled despite the best intentions of the licence premises. Thank you.
So just to clarify then, what you're saying the evidence is in your experience?
That's correct, yes.
And could you tell us a little bit more about your experience? I think that would be helpful.
In general, I have been an environmental health officer for 27 years. The issues around licensed premises, in particular since the deregulation around music and the hours that music can be played, I've experienced many complaints in this regard, and it is really difficult to control.
Thank you. Mr. Semper?
Can I just come in on that? That each application, I need to remind everybody that each application must be considered on its own individual merits, and you've taken no evidence against this premise or so this operator whatsoever. The fact that this lady has got a lot of experience, and I don't question or whatever, and she's an expert in her field, but she's having problems elsewhere in different circumstances, I'm afraid I have to put my hand up and say that's not a relevant consideration, ma'am, in my opinion.
Okay, so thank you everyone for the clarity there. So we need an opportunity to consider what we've heard today. Can I ask everybody to withdraw to allow the panel to do that? Oh gosh, that's a good question. How long's a piece of string? We don't know how long it's going to take. It's difficult to say how long we're going to take. Hopefully not for too long. We won't be inconveniencing everybody for too long. Possibly. Thank you. Thank you, everyone, and thank you for your patience. So the panel today were asked to consider the application for the grant of a new premises licence in respect of Mapplewell Bottle Shop Limited, situated at 337 to 339 Wakefield Road. We had an opportunity to hear representations from everyone, and we've come to a decision on what to do in respect of the application. So we have considered what's been heard, the evidence that's been given. We've particularly considered what has been said about the outdoor space, and the panel have taken the following decision. To grant the licence with conditions as follows. Retail sale of alcohol on premises as applied for Monday to Sunday, 12 a.m. to 11:59 p.m, so 24 hours. But in respect of retail sale of alcohol off licence, specifically in relation to the rear, namely the beer garden, as described in the application, or rear outdoor space, we've taken the decision to allow licensing activity between the hours of 10 a.m. to 8 p.m, and that's taking account of the revised operating schedule and also the noise management plan. Okay? Can you just bear with me a moment? Okay, so I just want to clarify something there. So the decision has been made based on considering the licensing objectives, particularly looking at statutory nuisance, looking at crime and disorder, and protection of children from harm. So thank you everyone for attending, and enjoy the rest of your day. Thank you. We'll confirm the decision in writing as well to all those concerned. Okay, thank you. Bye-bye.